Group A. According to feminist legal theory, the man and women have different biological roles. The recognition of the female biogenic roles provides a grounds for special protection of women's reproductive rights. The concept of equality starts with recognition of differential roles and protection of rights accordingly. Do you agree with this argument? Justify with logical arguments in for or against. Answer: I agree with the argument that, according to feminist legal theory, men and women have different biological roles, and that recognition of women's biogenic and reproductive roles provides a valid ground for special protection of women's reproductive rights. Feminist jurisprudence does not reject equality, rather, it redefines equality by recognizing difference and responding to it through law and policy. Feminist legal theory critiques the traditional liberal concept of formal equality, which treats men and women as similarly situated and therefore deserving of identical treatment. Such an approach often ignores the biological realities of women, particularly pregnancy, childbirth, menstruation, and reproductive health. These biological functions are unique to women and have historically placed them at social, economic, and legal disadvantage. Ignoring these differences in the name of formal equality can result in indirect discrimination against women. Substantive equality, as advanced by feminist jurisprudence, starts with the recognition that unequal situations require differential treatment to achieve real equality. Women's reproductive roles expose them to specific risks, such as maternal mortality, workplace discrimination, health vulnerabilities, and unequal caregiving burdens. Therefore, providing special protection for reproductive rights such as maternity benefits, reproductive healthcare, protection from dismissal during pregnancy, and access to family planning is not preferential treatment but a corrective measure aimed at achieving genuine equality. International human rights law supports this feminist approach. The Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, explicitly recognizes that special measures aimed at protecting maternity and reproductive health shall not be considered discriminatory. This demonstrates that equality in law is not undermined by special protection; instead, it is strengthened by addressing structural and biological disadvantages faced by women. Moreover, constitutional jurisprudence in many jurisdictions, including Nepal, India, and South Africa, reflects this understanding. Courts have upheld laws granting maternity leave, reproductive healthcare, and affirmative protection for women on the basis that such measures promote substantive equality. These legal developments align with feminist jurisprudence, which views law as a tool to dismantle patriarchal structures rather than reinforce them through rigid notions of sameness. Critics often argue that recognizing biological differences reinforces gender stereotypes. However, feminist theory distinguishes between recognizing biological realities and imposing socially constructed gender roles. Special protection for reproductive rights does not confine women to motherhood; instead, it enables women to exercise reproductive choice with dignity, autonomy, and safety. Without such protection, women are forced to bear disproportionate costs of reproduction, thereby limiting their participation in education, employment, and public life. In conclusion, I agree with the argument that equality begins with recognizing differential biological roles and protecting rights accordingly. Feminist jurisprudence offers a more realistic and just understanding of equality, one that moves beyond formal sameness and embraces substantive fairness. Special protection of women's reproductive rights is not a deviation from equality but an essential requirement for achieving true gender justice in law and society. Catherine McKinnon on the theoretical perspectives of radical feminism and examined the effect of its methods in emancipation of women. Answer: I agree with Catherine McKinnon's theoretical perspective of radical feminism and her analysis of women's oppression within law and society. McKinnon's work is central to feminist jurisprudence because it exposes how law is not neutral but reflects and reinforces male dominance. According to McKinnon, radical feminism views gender inequality as a product of systemic power imbalance between men and women. She argues that sexuality is the primary site of women's oppression, where men exercise dominance and women experience subordination. Practices such as sexual harassment, pornography, rape, and domestic violence are not isolated wrongs but structural mechanisms through which patriarchy maintains control over women. In this sense, McKinnon challenges traditional liberal feminism, which focuses mainly on formal equality and individual rights. McKinnon's methods of emancipation emphasize transforming the legal understanding of harm and inequality. One of her most significant contributions is the recognition of sexual harassment as a form of sex discrimination. By framing sexual harassment as a violation of equality rather than merely personal misconduct, she successfully brought women's lived experiences into legal doctrine. This approach has influenced laws and judicial decisions in many jurisdictions, contributing to greater legal protection for women in workplaces and educational institutions. Further, McKinnon's critique of pornography argues that it institutionalizes sexual inequality by objectifying women and normalizing violence and subordination. While controversial, this perspective has sparked important debates about freedom of expression and women's dignity, forcing the law to confront the social consequences of sexual exploitation. The effect of radical feminist methods in the emancipation of women is significant. They shift the focus from formal equality to substantive equality and expose hidden forms of domination embedded in law. Although critics argue that McKinnon's approach may limit sexual autonomy or free speech, her work has undeniably advanced women's legal recognition and protection. In conclusion, I agree with McKinnon's radical feminist theory because it offers a powerful and realistic critique of patriarchy and uses law as a tool for meaningful emancipation of women. Competition, sharing, and power exercise between sexes is natural. However, subordination of women is not a natural phenomenon, it is a societal creation due to unequal power exercise between males and females. Explain the statement highlighting the functional relation between change, progress, and equality. Answer: I agree with the statement that competition, sharing, and power exercise between sexes are natural, but the subordination of women is not a natural phenomenon, rather, it is a societal creation resulting from unequal power relations between men and women. Feminist jurisprudence provides a critical framework to understand how legal and social institutions have historically reinforced male dominance, while the marginalization of women is socially constructed rather than biologically predetermined. From a feminist perspective, power is the central axis around which gender inequality operates. While both men and women participate in social competition and cooperation, societal norms and legal structures have historically privileged men, granting them greater authority in economic, political, and domestic spheres. This unequal power exercise is perpetuated through cultural practices, legal codes, and institutional biases, creating systemic subordination of women. Radical and liberal feminist theories converge in recognizing that gendered hierarchies are socially maintained and can be challenged through legal and societal reforms. The functional relation between change, progress, and equality is crucial in this context. Social change occurs when existing power relations are questioned, and discriminatory practices are challenged through legal interventions, education, and advocacy. Progress is measured not simply by formal equality or legal recognition but by substantive equality, where women can exercise their rights fully and participate equally in decision-making processes. Feminist jurisprudence emphasizes that equality is both the goal and the mechanism of progress. Laws addressing sexual harassment, reproductive rights, equal pay, and representation in leadership are examples where change in legal frameworks facilitates social progress and reduces structural inequality. Furthermore, feminist legal theory highlights that true equality requires constant adjustment of social and legal norms to reflect changing realities. As women gain greater access to education, employment, and political participation, power relations shift, enabling more equitable sharing and exercise of authority. The dynamic interplay of change and progress ensures that gender equality is not merely formal but embedded in the functional operations of society, challenging the historical subordination of women. In conclusion, subordination of women is not natural, it is socially constructed through unequal power dynamics. Competition and sharing between sexes are natural, but meaningful equality is achieved only through deliberate social change and legal progress. Feminist jurisprudence provides both the theoretical lens and practical guidance to understand, critique, and transform these power structures, ensuring that equality is substantive, dynamic, and reflective of genuine emancipation for women. Use of technology and science has controlled to break the stereotyped roles of women, and as such has provided rich grounds for achieving socialization and self-confidence by women. Answer: I agree with the statement that the use of technology and science has helped to break the stereotyped roles of women and has provided a strong foundation for socialization and self-confidence. Feminist jurisprudence recognizes that gender inequality is socially constructed, and traditional roles assigned to women often restrict their personal, social, and professional development. In this context, technology and scientific advancements have become important tools for empowerment. Access to technology, such as the internet, digital platforms, and information systems, allows women to challenge societal expectations and participate in areas traditionally dominated by men. For example, online education and e-learning provide opportunities for women to acquire knowledge and skills without being limited by geographical or cultural constraints. Similarly, advancements in healthcare and reproductive technologies have given women greater control over their bodies and life choices, enhancing autonomy and self-determination. Science and technology also facilitate socialization by connecting women to wider networks and communities. Social media platforms, professional networks, and collaborative technologies enable women to share experiences, support each other, and engage in collective action for gender equality. This interaction strengthens self-confidence and encourages women to assert their rights in social, economic, and political spheres. From a legal perspective, feminist jurisprudence emphasizes that the law must recognize and support such empowerment. Policies that ensure digital access, education, and workplace equality complement the benefits of technology and science. By breaking stereotyped roles and enabling women's participation, these tools help translate formal equality into substantive equality, which is central to the feminist legal framework. In conclusion, technology and science have not only challenged traditional gender roles but also created opportunities for women's socialization and self-confidence. Feminist legal theory supports the use of these tools as a means to achieve real equality, ensuring that women can participate fully in all aspects of social and professional life. Group B. Critically analyze the legal provisions governing abortion in Nepal and explain how they attempt to harmonize women's reproductive rights with the interests of the state. Answer: Nepal's legal framework governing abortion represents an effort to balance women's reproductive rights with the state's interest in regulating maternal health and public policy. The Constitution of Nepal guarantees the right to safe motherhood and reproductive health, recognizing reproductive autonomy as a fundamental human right. The Safe Motherhood and Reproductive Health Rights Act, 2075, 2018, provides women with a legal right to safe abortion on request up to 12 weeks of gestation and under broader health-related and socio-legal grounds up to 28 weeks, including rape, incest, risk to the woman's physical or mental health, and serious fetal abnormality. Importantly, the woman's own consent is mandatory and spousal consent is not required, affirming her agency and choice. However, Nepal's current regime is not free of tension. Abortion remains criminalized under the National Criminal Code outside the statutory allowances, subject to penalties, creating an ambiguous legal environment criticized by advocates who argue that criminalization undermines reproductive rights and debtors' access to safe services. This tension illustrates the state's attempt to protect fetal life and regulate medical practice while affirming women's autonomy. From a feminist jurisprudence perspective, these provisions reflect a partial harmonization. They advance substantive equality and challenge patriarchal constraints on reproductive autonomy, yet the persistence of criminal sanctions indicates unfinished legal reform. Overall, Nepal's law seeks to merge individual reproductive rights with public health objectives, though further alignment is necessary to fully realize reproductive justice. Analyze the rationale behind treating prostitution and human trafficking as separate legal concepts in Nepal and discuss the respective legal outcomes. Answer: In Nepal, prostitution and human trafficking are treated as distinct legal concepts, reflecting different policy rationales and legal outcomes. Prostitution, understood as consensual sexual activity for remuneration, is not explicitly criminalized as an autonomous offense under Nepali law. However, soliciting and related public order offenses are penalized under the Penal Code, and brothel keeping and associated activities face restriction, effectively criminalizing aspects of consensual sex work in practice. These provisions reflect concerns about public morality and social order rather than a direct focus on exploitation alone. By contrast, human trafficking is clearly defined and criminalized under the Human Trafficking and Transportation Control Act, 2064, 2007, as a serious crime involving force, coercion, recruitment, sale, purchase, or exploitation of persons for labor or sexual purposes. The law imposes stringent penalties, including long terms of imprisonment and fines, for trafficking offenses, notably where persons are forced into prostitution or taken across borders for exploitation.
The legal separation recognizes that not all prostitution involves trafficking, and that exploitation and coercion are core to the offense of trafficking.
This distinction aligns with international norms emphasizing consent. Trafficking involves exploitation through deception, coercion, or abuse of power, whereas prostitution may involve consensual adults. The state's approach seeks to penalize exploitative conduct while ostensibly differentiating it from consensual adult activity, although enforcement often blurs these lines in practice. In legal outcomes, sex workers may face arrest under public order provisions, whereas traffickers face severe sanctions reflecting the gravity of human rights violations. This conceptual separation aims to protect victims of trafficking while balancing social policy on prostitution, although feminist critics argue that criminalization of aspects of sex work can inadvertently harm vulnerable women. Discuss legal framework and penalties relating to statutory rape in Nepal and evaluate how these provisions protect minors from sexual exploitation. Answer. In Nepal, the legal framework addressing statutory rape is principally grounded in the Muluki Criminal Code, National Penal Code, 2074, which sets the age of sexual consent at 18 years. Under Section 219 of the Code, any sexual intercourse with a person below 18 years of age is considered rape, regardless of consent, reflecting a strict approach to protect minors from sexual exploitation. This provision recognizes that minors lack the legal capacity to provide valid consent due to their cognitive, emotional, and social immaturity.
The sentencing regime illustrates the gravity with which Nepal treats sexual conduct involving minors.
Punishments vary by age. Offenses involving victims under 10 years attract longer imprisonment, and offenders can face significant custodial sentences ranging up to life imprisonment in aggravated cases such as rape of very young children. Likewise, rape of adolescents aged 16 to 18 carries substantial prison terms, underscoring the state's commitment to deterrence and child protection. Complementing the Criminal Code, the Act Relating to Children, 2075 prohibits any form of sexual abuse or exploitation of children, including acts beyond intercourse such as inappropriate touching or coercive sexual conduct. This dual statutory framework aims to ensure comprehensive protection for minors across various forms of sexual harm. From a feminist jurisprudence perspective, these legal provisions align with international child rights standards by prioritizing the inherent vulnerability of minors and affirming the state's duty to safeguard children against exploitation. The strict liability approach, where consent by a minor is legally invalid, recognizes that social and gendered power imbalances can leave children especially susceptible to coercion and abuse. Legal protection through punitive sanctions serves not only to punish offenders but also to signal a societal repudiation of the exploitation of young bodies. However, feminist critics also caution that an overly rigid application of statutory rape rules may result in unjust outcomes in cases where consensual behaviors between peers are criminalized. There have been judicial discussions suggesting a need for more contextualized analysis, such as considering mens rea, criminal intent, and the nature of relationships, especially among adolescents, to avoid unintended harm to minors within consensual social contexts. In conclusion, Nepal's legal treatment of statutory rape reflects an intentional effort to protect children from sexual exploitation through clear age-based prohibitions and significant penalties, while ongoing legal and social dialogue continues to shape how these protections are balanced with fairness and context-specific justice. How can feminist legal methods be applied to reinterpret traditional legal concepts such as justice, rights, and equality to better address gender disparities? Answer. Feminist legal methods provide a critical lens to reinterpret traditional legal concepts such as justice, rights, and equality in ways that directly address gender disparities. Conventional legal doctrines often adopt a formal or neutral approach, assuming that laws apply equally to all individuals. However, feminist jurisprudence argues that such formal equality frequently masks the social and structural inequalities that women face. By applying feminist methods, law can move from formal equality to substantive equality, recognizing and correcting power imbalances between men and women. In terms of justice, feminist legal methods emphasize fairness that accounts for social context and lived experiences. Justice is not only about impartial application of rules but also about recognizing historical disadvantage, social roles, and systemic discrimination. For example, legal remedies can incorporate considerations of caregiving responsibilities, workplace inequality, and reproductive autonomy to achieve outcomes that are genuinely just for women. Regarding rights, feminist approaches advocate for the expansion and redefinition of legal rights to reflect women's specific needs. Rights related to reproductive health, protection from domestic and sexual violence, and participation in economic and political life are interpreted not merely as optional privileges but as essential entitlements necessary for substantive equality.
Equality, in feminist jurisprudence, moves beyond sameness.
It acknowledges difference and seeks to remove structural barriers that prevent women from enjoying the same opportunities and protections as men. Laws are therefore reinterpreted to accommodate social realities, ensuring that legal principles support women's empowerment rather than reinforcing existing hierarchies. In conclusion, applying feminist legal methods allows traditional concepts of justice, rights, and equality to be recalibrated in ways that meaningfully address gender inequality. This approach promotes laws that are context-sensitive, protective of women's interests, and capable of transforming societal structures that perpetuate discrimination.